crowd gets out of control, let me know.
Oh, that's a good one.
All right, outstanding. Okay, good morning.
Morning, Your Honor.
All right, this is the Michigan Court of Claims. I am James Redford. I'm the judge who's been assigned the matter of Cage versus Michigan State Police. It is Andrica Cage as the personal representative of the estate of Samuel Sterling. This is case 25-10-MZ. Mr. Trudell, thank you for being with us today. Counsel, Mr. Trudell is our court reporter. If he needs to, if one of us is not speaking in a way that he's able to pick everything up, he'll interrupt us, as I always ask him to. He had the privilege of having him on a number of cases. So, Mr. Trudell, thanks for being here. Appreciate it. If I could have appearances of counsel, plaintiffs first.
Good morning, Your Honor. Christopher Desmond from Venn Johnson Law on behalf of the plaintiff, Andrica Cage as personal representative of the estate of Samuel Sterling.
Thank you, Mr. Desmond. Good morning.
Good morning.
Good morning, Your Honor. Mary Waddell, Assistant Attorney General, appearing on behalf of the defendant, the Michigan State Police.
All right, thank you. All right, the court, and I know this matter has been fully briefed for an extended period of time, and I want to just say I'm sorry that I haven't gotten this resolved, these motions resolved, this motion resolved previously. Mr. Desmond appears in a couple of other cases, so he knows that the court has a couple of matters on its docket that have been
Others.
taking up some of the time that the court has available to, but I feel I'm candidly embarrassed that it's been pending this long. But anyway, we'll seek to remedy that soon. But after reviewing it, talking about it with the lawyers who assist the court, I made a determination I wanted to have the benefit of oral argument from both sides. So I have reviewed the pleadings, I've reviewed the briefs, I've reviewed many of the cases that are cited. I will not say before God and these witnesses that I've reviewed 100% of the cases that are cited, but I'm familiar with the concepts and the statute, of course. So with that, the moving party is the state. Ms. Waddell, you may proceed.
Thank you, Your Honor. As the court has read all the briefing, I will be brief. Obviously, this is a governmental immunity issue. The plaintiff is attempting to sue the state police under the motor vehicle exception to governmental immunity. Our position is that the state is not an owner of the vehicle. As such, the state is entitled to immunity.
So the question that I have, Ms. Waddell and Mr. Desmond, you'll have a chance to answer this too, is there a factual question of who the owner of the vehicle is? We have the statements that are averred in Mr. Desmond or Mr. Desmond's colleagues' complaint that gives rise to the litigation itself. We have the affidavit that's been proffered by the people. That to me is the essential issue. Is there a question of fact as to the ownership?
So our position is no, Your Honor. Obviously there's three different ways under the statute that the state could be the owner. Obviously, if it's titled in the state of Michigan, I don't think plaintiffs, as I read their brief, I don't think plaintiffs are disputing that anymore. Clearly, this vehicle was not purchased by the state of Michigan. It is not titled by the state of Michigan. I think they're pivoting to this argument about exclusive use. Our position is they have not created a genuine issue of fact as it relates to exclusive use. We have proffered the testimony of the Deputy U.S. Marshal Ortiz, who testified in the criminal case that this vehicle is to be used exclusively for Marshal Service operations, so a federal use, not a state use. They have not submitted any evidence in response to that assertion to create a genuine issue of material fact in this case. So our position
is there evidence, Ms. Waddell, of the, I think both the lawyers, I know Mr. Desmond knows, or I'm pretty sure he does, and I suspect you might know, Ms. Waddell. In a prior life, I was a federal prosecutor. I did handle task force cases, had many times where agents for various state and local agencies were assigned to any number of federal task forces. The question I have is, as relates to the vehicle which was involved in the very, very unfortunate death of this young man, was the officer who was assigned that vehicle, I mean, could he drive that home? Could he take that to Myers to get groceries? Was he able to use this for, or was it something where he would drive his own personal vehicle into wherever the fugitive, I think it was a fugitive task force, is that right?
That's correct,
Okay,
Your Honor.
wherever the fugitive task force was operating out of, would he drive his own, as we used to say in the Navy, POV, personally owned vehicle there, and then use the government issued vehicle? What is the evidence of record, if any, on those issues?
So to my knowledge, the only evidence that's been submitted in this case would be Sergeant, Ortiz's testimony. He could not recall whether Keeley was allowed to take the vehicle home, but he did emphatically testify that the vehicle was only to be used for federal operations. So for example, he couldn't use it if he's working on behalf of MSP out patrolling or whatever. He can't use this vehicle because it's an undercover vehicle. So that's my understanding of what is in the record for this case.
All right, thank you. What else would you like to share with the court this morning, Ms. Waddell?
So that's all, with the exception, I would just touch on the unpublished case, the Wayne County case that the plaintiffs attached in support of their argument. And I would say that case should be disregarded by the court for two reasons. First of all, it's unpublished and unpersuasive as it relates to these issues. Second, it's very distinguishable. In that case, all of the arguments that Wayne County was making with respect to their officers only being able to use it, 8 hours of a 24-hour day or only on certain days of the week, all of those arguments that went to exclusive use were not raised below. So when the Court of Appeals was evaluating whether or not summary disposition had been appropriate in that case, it had to disregard all of that factual record that they were trying to rely on appeal, which is obviously the opposite of what we have here. We are raising all of these issues below as it relates to exclusive use. So that case is distinguishable. It's not controlling here. The bottom line is there's nothing in the record that the plaintiffs have submitted to challenge the argument related to exclusive use, and certainly related to the title or the ownership of the vehicle. As we've indicated in our reply brief, Sergeant Avery candidly spoke out of turn and without knowledge about the titling or the ownership of this vehicle. He has since corrected that errant statement, and therefore it does not create a genuine issue of material fact. So
is the statement of that witness admissible substantively?
I would say no, there's no foundation for it, Your Honor. So it wasn't objected to in I believe it was the criminal case, but no, I would say it's not. So.
Okay.
So again, that doesn't create a genuine issue of material fact. Reasonable minds could not differ, because if he is asked in a deposition, he's going to say he was mistaken. We obviously have submitted all of the other evidence related to the titling of this vehicle. This vehicle is not insured by the state of Michigan. So really it's this exclusive use notion. But again, there's nothing in the record that creates a question of fact related to exclusive use. They have not refuted anything that Ortiz testified to. Therefore, we're entitled to a judgment in this case because we are immune.
All right. Thank you, Ms. Waddell. Mr. Desmond, before we hear from you, I want to review the unpublished case that was attached to your pleadings. I think it's at page 67 and 72 of your appendix. Is that right?
I think that's roughly right, Your Honor. It's about a 70-page appendix, and that's the last document in it. So
Okay. Let me have just a minute to refresh my memory here, please.
absolutely.
No, you're getting older when you have to find the part of your computer screen that makes the type larger.
Oh man, I have been having that problem for the first time in life in the last couple of weeks, and it's.
You're a young guy, Mr. Desmond, relative to me. Wait till you get to be my age.
I hope I'm doing as well as you, Your Honor.
Oh, well, guy, no harm in a rule on this motion. Let's, okay, hold on. Thanks. All right, Mr. Desmond, good afternoon. Good morning.
Morning, Your Honor.
It's nice to see you again.
You as well.
So you've heard my questions to Ms. Waddell. What factual issue that contravenes the proffered affidavit exists in your estimation to require the court to deny summary disposition under the C10 theory?
Right. So Your Honor, one thing.
And it's, I know it's a sort of this, I say C10
Right.
for purposes of appellate review. The reason I say C10 to my appellate colleagues on the Court of Appeals, I hear they're all very fine judges on that court. But and I say they are fine judges with the exception perhaps of me. But the reason I say C10 is at this point, is there a factual question based on admissible evidence as to the ownership under MCL 257.1? So that's why it may be captioned as a 6 or a 7 or an 8C motion 2116C, but the gravamen of what I have to decide, I think, is have you proffered enough evidence to keep the case going forward?
So, Your Honor, I think the answer at this stage absolutely is yes. And the primary form of that evidence, I think, is Sergeant Avery's testimony. I know there's questions about whether it's admissible. I think what the court rules generally require is that the evidence in support of a response or a motion not necessarily be in admissible form itself, but that it be representative of evidence that will be able to come in.
How does it come in?
Well, ultimately, what will depose Sergeant Avery in this case? We haven't yet because discovery hasn't even commenced. So this is essentially a first responsive pleading from the state saying we have this vehicle.
Right. So work through that with me. And I know you work obviously with Mr. Johnson, who I hold in very high regard, both personally and professionally. And I know I've seen you in court now many times in the Edenville Dam case, as well as in any number of other matters.
Yes,
and you're very capable, but how do you get that evidence admissible as substantive proof of satisfaction of the statutory requirement.
So I think what it does, Your Honor, is so when we depose Sergeant Avery, one of two things is going to happen. He's either going to testify consistent with the preliminary exam and say, look, I was the individual who was responsible for getting the search warrant for this vehicle. So I had to make sure I knew who owned it. And I checked, I did my research, and it's the state of Michigan. Or he could do what's now in the police report, which, by the way, is also inadmissible evidence, of course. But the police report, that's what
That is my understanding.
Yeah. So that's what the state is referring to, Your Honor, when they say that Sergeant Avery has corrected this notion that the state owns the vehicle. All he did was amend a UD-10 to say that the owner is the federal government. I think, frankly, that nothing that Sergeant Avery could say and nothing that any of these witnesses who've submitted affidavits could say is necessarily dispositive on this issue. And the reason I say that, I think, is kind of evident from two cases that I've presented to the court. The first is, and this isn't a huge opinion that the court needs to really be very familiar with, but Bazgal v. Kovich is a case that I cite to in my brief, just for the simple proposition that you can have multiple owners of a vehicle under MCL 257.37. And what I think the Wright versus Wayne County opinion that this court just took time to review demonstrates is that you could have one entity that has title to a vehicle. So we could have, and I'm not conceding this because I haven't seen a title yet, but we could have the federal government with a titled vehicle in some other state or in Michigan. Wright demonstrates that depending on the way in which that vehicle was used, it could also be considered the property of the state of Michigan as well. And so I think where we have that testimony for Sergeant Avery, I understand the court referenced the affidavit of, I believe it's Mr. Ortiz, who is the individual from the U.S. Marshals, the deputy supervisor. You know, Your Honor, I know obviously courts aren't in a position to make credibility calls, but there's sort of an interesting thing that's already jumped out to me about this Ortiz affidavit. He states in there, you know, this was a operation of the U.S. Marshal Service. This was a fugitive task force operation. I was supervising at all times. I was in charge of what Defendant Keeley was doing at all times on that day. Well, if you go and you look at the evidentiary hearing that defendant has given to this court, I think it's page 96 and 97 maybe of that evidentiary hearing, Judge Jarboe takes over at one point and starts questioning the witness and saying to, I apologize, this witness isn't Mr. Ortiz, this is Deputy Ross Egan. So Deputy Ross Egan from the Wyoming Police Department is testifying about that day, and Judge Jarboe asks him very concisely and frankly, did the federal government have authority that day? Could someone from the federal task force have shown up and said, hey, this is where these people are going to go. This is how we're going to do this. And his response is, it's a fluid situation. There are certain days where that's the case, but not this day. This was my operation this day. I was supervising. So we have Egan saying that this was a Wyoming Police Department and impact operation. We have the feds saying in an affidavit it was their operation. I think there's a lot of uncertainty about what Mr. Keeley was doing that day, and more important than what he was doing that day, what his history with that vehicle was. Your Honor, you are asking questions to defense counsel that frankly are the precise questions we'll be asking in depositions and that we haven't had an opportunity to ask yet. Where does this vehicle go at night? Does he take it home with him? Does he drive it on other occasions? I don't even know how frequently, frankly, Mr. Keeley is doing things or was doing things in service of this fugitive task force. Is it 10% of his time or 80% of his time? If it's 10% and he's using the vehicle all the time, I think that creates a real different question regarding ownership. And so where we know that you can have multiple owners and that this can be something that requires a factual record, right, of course, is a case that had discovery, and the court references the discovery materials. And so what we're dealing with right now, I understand, you know, the state could have its meritorious arguments going forward, but we're dealing with a complaint that specifically alleges at paragraph 7 and 44 that the state owned this vehicle. So we say it.
Hold on just a sec. I want to get to the complaint itself. We, through the leadership of our chief judge, Judge Schwartzel, we now have a computer system for our documents in the Court of Claims, very similar to the Court of Appeals. So it's
Really nice.
really a step up. What paragraph of the complaint, please?
So 2 paragraphs, Your Honor, paragraph 7 and paragraph 44.
Okay, please continue.
So in light of those allegations, Your Honor, which I don't think have been refuted, the only other point I kind of want to make about the effort to refute that through these affidavits, and this is the reason why I say no individual opinion of any of these individuals can be dispositive on this issue right now. When you look at a case like Wright, you have an example of 3 experienced judges of the Court of Appeals analyzing all the different aspects and elements of ownership and how ownership can look differently and take different forms. Respectfully to Mr. Ortiz, Sergeant Avery is a little bit of an exception, but the other 3 individuals from the state that have submitted affidavits, I don't know what concept of ownership they're using when they say in their affidavit, the state of Michigan didn't own the vehicle. They're not referencing statutory authority. I don't know that they're well-versed or grounded in the concepts of ownership under the Motor Vehicle Code. I don't know that they have any familiarity with how this vehicle was used on a day-to-day basis. My understanding when I look at those affidavits, or I won't say my understanding, we haven't been able to speak with these witnesses yet, but my interpretation of those affidavits, it seems to me what they're essentially saying is the vehicle isn't titled to the state of Michigan. That seems to be the research that they did to figure out, do we have a vehicle with that VIN number that's titled to us and we don't? That may very well be the case, and I don't know that it is. But even if it is, Wright says that that doesn't mean that you're not the owner for purposes of MCL 691.1405 and 257.37. So I'd submit, Your Honor, that we need to proceed forward with discovery on this issue of ownership. If the court has any other questions, I'm happy to answer.
Do you think, Mr. Desmond, that the witness who the officer who testified at, like, I think it was the prelim, and I should have this in my notes and I apologize, but I don't. His statement of, well, the state owned it or whatever, is that statement, let's say you take his deposition and he says, I was mistaken. But even before he answers the question, if the opposing party interposes an objection foundation, objection hearsay, what would your response be?
So I think my approach would be a little bit differently than that, Your Honor. I think instead of just flat out saying, so just to back up very slightly, of course, the issues that are being discussed in the preliminary exam and in the evidentiary hearings in front of Judge Jarboe, they just kind of tangentially butt up on what we're doing today, because the focus of the court that day isn't who owns the vehicle. The court is probable cause and supremacy and other issues. But I don't think we'd ask that direct question to Sergeant Avery. I think it would be more geared toward questions that speak toward ownership. So we'd be asking him, when you were trying to get the search warrant, were you looking into who the vehicle was titled under? Because that speaks to 257.37A. Then with B, we could talk to him about exclusive use and possession, what he discovered about how this vehicle was used on a daily basis, who had access, who didn't. So it would be information like that. We could, I guess, in theory, ask all of these witnesses for their opinion on who owns the vehicle, but I could see the court having concerns about that. I think it's more so about building an evidentiary record that can then be presented to this court. And this court could look at it and say, well, you know what, Mr. Desmond, you just deposed 5 witnesses and every single one of them said the state doesn't have exclusive use, the state didn't have this for 30 days, there's no genuine issue of material fact. Or we could find ourselves in a situation where Avery says one thing, Ortiz says one thing, Keeley says one thing, and you say, you know what, this looks a little unclear, we need to proceed with trial, and I need to see these people testify in person to see their demeanor and assess their credibility in that traditional courtroom setting. So I think those are sort of the possibilities we're looking at right now.
That's very helpful. Thank you.
You're welcome.
Any other things you'd like to share before I open the floor back up to the attorney for the department?
Nothing else on my end, Your Honor.
Okay, thank you.
Thank you.
Ms. Waddell, you any additional thoughts, comments? As a moving party in the motion, you have burden, so you may offer a reply argument if you would like to. You don't need to, but you may if you would like to.
Thank you, Your Honor. I'll touch on a couple of things. I agree with my colleague that ownership does not mean just title. He did say he hasn't seen a title in this case because there isn't a title for this vehicle as we traditionally think of it. That is not required of federally owned vehicles. They're owned by GSA. That's why there's a certificate of origin in this case. So again, the title is not the issue here. This vehicle was never purchased by MSP. It is not titled to MSP, never has been. There cannot be a disputed fact about that. They haven't refuted that. The issue here is this exclusive use notion. And while I understand that Mr. Desmond may want to engage in a fishing expedition in the hopes that someone will say that MSP, and let's be clear, it's MSP that has to have exclusive use of this vehicle. That's what the statute requires. It's the government owner that you're claiming the government owns this vehicle. So MSP is the one that has to have exclusive use of this vehicle. There is nothing in the record to create a question of fact about that. The plaintiffs have not brought forth any affidavits, any witness statements, any documentation to refute Ortiz's testimony that the exclusive use of this vehicle was for federal operations by the task force office.
But counsel, Mr. Desmond and his colleagues at his firm have not had the benefit of sitting down with Officer Ortiz and deposing him. I mean,
they could have. I'm sorry.
Nope, please go ahead.
Oh, there is no reason that they can't reach out to Sergeant Ortiz and ask him to sign an affidavit saying otherwise. Like that's their burden here, Your Honor. Would we come forward with evidence on a C7? Honestly,
you're not here in the open court, but you can probably see it on the screen. I mean, do we really think no disparagement. My son is a law enforcement officer. I have great respect for law enforcement. I've represented agencies. I've prosecuted federal and state cases, military. I've defended federal, state, and military cases. Do you really think the officer is going to voluntarily sit down? And I'm not casting any dispersions on any officer, but in a case that's pending civil and potential criminal litigation, do you really believe that the plaintiff has access to that witness for those purposes? And they wouldn't say, no, thank you, Mr. Desmond. I don't think I want to talk to you. I mean, honestly,
Your Honor, whether or not he'd sit down for a deposition isn't what I'm saying. They can pick up the phone and ask.
okay.
So the burden is on them.
Let's follow that up.
Okay.
Let's assume that they do that. And let's assume that that which takes place is what I think all the lawyers on this phone call, and I'm including myself in the category of being a lawyer, having had the privilege of being one for a lot of years. I think all of us would probably anticipate they would probably say no, thank you, or talk to my assistant attorney general or anything else that would happen. So let's assume that's a response. So then where does that leave the plaintiff in responding to the affidavit of Officer Ortiz?
They can get an affidavit from Officer Ortiz. Your Honor, when you bring up a litigation like this, you do have a duty to do some due diligence.
Right.
And not, you don't get to just say.
I mean, you do have somebody who's a sworn officer of the law who said the state of Michigan owned it. I mean, that's, I don't know, that sort of sounds like that's enough due diligence. That's at least enough to get the ball started.
Right, but but what we're looking at here, Judge, is what has the plaintiff submitted, not what the plaintiff wants to find out. What has the plaintiff submitted to this court for this court to say, well, reasonable minds could differ about the testimony from Sergeant Ortiz. The court has to be able to point to evidence in the record before it today that creates a question of fact about that. Not a curiosity, not a fishing expedition, nothing like that. You have to be able to point to the evidence in the record that the court's considering today to say, yep, reasonable minds could differ about that. And there is nothing here about exclusive use. Nothing. So, and I would just submit for the court a question that came posed in my mind is if MSP did own this vehicle and Avery actually believed that MSP owned this vehicle, then what did he need a search warrant for?
Yeah, good point.
So based on that, Your Honor, we don't think they have created a genuine issue of material fact on this. MSP is immune and this case should be dismissed.
As I'm going through the opportunities I've had to sit down with this case with some super capable lawyers that we have on our court, hearing the very capable arguments of both counsel demonstrate palpably for me why I wanted to have a oral argument. So I really appreciate both of you. I think both of your arguments are excellent. I think both the briefs were excellent. I'd be happy listening. Final statement. I don't think I need one. I think you both are well articulated your positions, but if there's anything, final thing you'd want to say, Ms. Waddell or Mr. Desmond, before we complete our time together this morning, I'll give you the opportunity to do so, but I'm going to take the matter under consideration. I will say what was going to be a 2-week trial from December 8th through December 19th was settled on the record yesterday. So I'm going to have some time to, really do a dive. I do have case call. I'm 30 cases here, with Judge Kelly and Judge Feeney this coming Tuesday and Wednesday. So I know for sure I'm not going to be able to go right back into this case. But as soon as case call is done, I will have the opportunity to really spend some more time with this matter. But I'd be happy to listen to anything that you'd like to say. Any final comments, Ms. Waddell, beyond that, which is already on the record, or you, Mr. Desmond? Ms. Waddell?
No, Your Honor, thank you.
Thank you. Mr. Desmond?
I'll be extremely brief, Your Honor. Just one point that
Ms. Waddell, that's what he always says. So sit back and get comfortable, as I used to say to the jurors.
He's not wrong. He's not wrong. One very quick point regarding this notion that we didn't adequately plead facts speaking to exclusive use or control. We've pled ownership, and so one way you can get through to ownership is through exclusive possession and use and control. And so by pleading ownership, we satisfy that requirement. This is a notice pleading requirement. We don't need to do more. The only final point I'd want to make, Your Honor, I appreciate you recognizing the sadness of this tragedy. I know it's sort of an inescapable fact of this case. I just think that when we're dealing with a situation like this, we're dealing with the loss of a life of an individual who was supposed to be taken into custody peacefully and without issue. And I'm not even necessarily casting aspersion on why that happened. These are all things that'll be fleshed out in the future. But think to entertain motions for summary disposition based on an evidentiary record that hasn't been formed in a case of this magnitude would be doing a disservice to both the GTLA and this area of law in general, Your Honor. And so that's the only final thing that I wanted to say. But I really appreciate the court's time today. And I hope you have a fantastic Thanksgiving, each of you.
I appreciate everybody's time. And again, I apologize to the parties involved, the representative of the young man who passed away and to the department. This should not have taken so long for us to get together. And for that, I'm sorry, but I will have something completed by the middle part. I would say no later than December 15th, you'll have an opinion and order on this motion. And then we'll proceed in whatever manner the order and opinion concludes. And I'll be candid. I've not made a decision. I'm working through this case. It's a important case for the plaintiffs. It's an important case for defense. I get that. And I'm going to treat it with all the seriousness that the facts and the law require. And I'll do my best. And whoever the non-prevailing party is, we have an outstanding court of appeals. And I do say that with all seriousness, and I'll, I'm sure, correct any deficiencies that my pedestrian efforts will be putting forward. So thanks. I hope everyone has a happy Thanksgiving. Mr. Trudell, as always, appreciate you being with us. And if the lawyers order a transcript, if you could let the court staff know, as you always do, and we'll get a transcript too. So, but thanks so much.
Thank you, Your Honor.
Yep. Mr. Trudell, anything else?
All set.
Okay, thank you. All right, the time is 9:37 and the court stands in recess. I hope everyone has a pleasant day. Thank you.
You as well.
Judge, thank you.